well. Welcome to the 18th of June 2025 virtual meeting on Premier and Constitutional Matters in the Western Cape. Just to prove it is in fact me. There's not some voice from ether just talking to you. So I want to welcome everyone to our meeting today, as well as I know we have some people visiting. So I also want to welcome Advocate Ashley Searle, who is here, and I believe Advocate Shukrat Makinde is also here. Just to begin with the issue of the apologies, we've had a number of apologies today. Honourable Syed, Honourable Heron, and Honourable Philander have sent apologies. We have Member Johnson sitting in for Member Philander. Member Badenhorst from the NCOP has also sent apologies. So I think for the record, if we could please just ask people to introduce themselves so we just know who is here, and then we can proceed. So I'll start with Aunt Benedicta van Minnen from the Western Cape Ledge, and I'm the chair of this committee. Thank you.
Hi there, Chair. I'm Leon van Wyk. I'm a member of this committee.
I'm Thomas Walters. I'm a member of this committee.
I'm Donita Stevens, and I'm a member of this committee.
I'm Lecker and alternate to this committee, but today standing in for Member Khalid Syed. Thank you.
Good afternoon, Chairperson. My apologies. I'm Peter Johnson. I'm an alternate for Member Wendy Kaiser Philander.
Okay, I think that's everybody. So, right, just to look at our agenda, there is a briefing by the Department of Public Administration on the Public Service Commission bill, which is something we're going to have to deal with, which is separate to the two bills we have to discuss subsequently. Then we have to consider and adopt a negotiating mandate report on the Public Service Amendment Bill and the Public Service Management Amendment Bill. As you can hear, they're all easily distinguishable by their names. We have two separate mandates we'll be looking at. And then we can look at the way forward in terms of hearings for the Public Service Commission Bill. So if we could please then start. Who do we have here from the department to talk to us about the Public Service Commission Bill? And are there any opening statements or remarks that are going to be made?
Good afternoon, Chairperson and honourable members. My name is Ashley Searle. I'm the resident commissioner for the Public Service Commission in the Western Cape. I'll be leading the delegation today. Joining me is Advocate Shukrat Makinde. She's our head of legal services at the Public Service Commission. She's the one that will actually be doing the presentation. But before with your indulgence, before I ask her to proceed with the presentation, if you would permit me to just make a few opening remarks, Chairperson.
Please go ahead.
Thank you very much. I need to tender at this stage an apology on behalf of our chairperson, Professor Somadoda Fakeni. Prof. Fakeni, as well as the DG and our CFO, they're currently busy at the National Assembly attending a meeting that was arranged at the last minute. So unfortunately, they're not in attendance today. Prof. Fakeni did indicate he might be able to join us, subsequent to that meeting ending. But we'll keep an eye on the lobby to see if he has in fact made it. Chairperson, we're very thankful that you've provided us with an opportunity to address you today on what from our perspective is a very important piece of legislation, the Public Service Commission Bill. This is a piece of legislation that has been in the works, so to speak, for an extended period of time. I joined the Public Service Commission in April last year, and one of the assignments that was given to me by the chairperson was to lead this process. And I soon became aware that this is something that's been going on from the mid-2000s. The Public Service Commission has gone through a variety of iterations of developing the bill. As you'll hear from Advocate McKinley, she'll give you the complete contextual background to the processes that we followed in developing the bill. And thankfully, we're now at the stage where we're at the NCOP process. I also want to note that one of the drivers of the development of this particular bill was Parliament itself, National Parliament. In 2011, there was a resolution adopted by Parliament which obligated the Public Service Commission to report on the integration of its work on the constitutional values and principles as is outlined in Section 195 of the Constitution, and that integration to take place across all spheres of government. So that was also one of the one of the pointers and the drivers towards the Commission developing what you now have in front of you as the Public Service Commission bill. As I said, it's been a long process. Unfortunately, we've had a number of different political principles over the past number of years, and that has impacted on the progress of the bill. Every opportunity that we've had to actually progress the bill, there would be a change in political principle, and that delayed the progress of the bill. I think my chairperson indicated to me that over the past number of years, we've gone through between 5 and 6 different political principles, and that, as I said, has impacted on the progressing of the bill. We were very relieved that the bill progressed quite a way under the 6th administration, but unfortunately, the legislative process couldn't be completed before the end of the 6th administration. The bill then lapsed, but thankfully, when the 7th administration took office, the bill was revived, and we are eternally grateful to the Portfolio Committee for Public Service and Administration for working quite vigorously on processing this particular piece of legislation. This ultimately led to the bill being adopted unanimously, I might add, Chairperson, by all parties represented in the Portfolio Committee on the 5th of March 2005, and thereafter the National Assembly adopted the bill on the 18th of March 2025. And hence we're at this process now, where we're heading through the NCOP process. The presentation will outline a number of issues. We'll go through not necessarily a clause-by-clause analysis of the bill, but Advocate Makinde will go through the main issues within the bill, the issues of importance. But I think it's important for us just to outline the two main objectives as we see it as the Public Service Commission as to why this bill was developed. So the first priority, Chairperson, is to ensure that the Public Service Commission obtains its true independence. Currently, we are unlike the other Chapter 9 constitutional entities who are outside of government. Our organizational structure leads us to still be within government, if I can use that phrase. We seem to be part of the Public Service and Administration stable of departments, and we report to the Minister of Public Service and Administration. Obviously, that is a challenge as a constitutional body. I doubt that the drafters of the Constitution envisaged a scenario where a constitutional body will actually be housed within government. In fact, there's case law on this particular issue, and Advocate Makinde will speak to it a little bit, where a matter that served at the Constitutional Court between the IEC and the Langeberg municipality, if my memory serves me correctly, where the Constitutional Court in fact said that the independence of a constitutional body must be seen to be taking place. And currently, with us located within the organization of government, that poses some challenges. So one of the key priorities of this bill is to ensure that we are extricated from the infrastructure of government and become a independent structure similar to the public protector and all of the other Chapter 9 institutions. And I'm sure members can understand some of the challenges that this current scenario can result in if you particularly refer to what our key mandate is. So we are monitoring an oversight body in terms of the Constitution, and we have the power and the function to, amongst others, conduct investigations and inspections related to service delivery, and to identify if certain policies and procedures within government is adhered to. So if we are in the sphere of the infrastructure of a government department, that impacts on our ability to be perceived as being completely independent. We do investigations across national and provincial government that involves departments that service us, for example. DPSA, the Department of Public Service and Administration, as a service department to the Public Service Commission, as well as CETA, for example. We're reliant on them at this stage for all our IT infrastructure. Yet, currently, for example, we're busy with an investigation into CETA, and that perceived conflict of interest is an issue that needs to be addressed, and the bill intends to address that particularly. The second key priority, Chairperson, is the confirmation, as we call it, of the extended mandate of the Public Service Commission. Currently, in terms of the Public Service Commission Act that is in place, our mandate only extends to national and provincial government. This bill now seeks to extend that mandate to both public entities as well as municipalities. And we are aware of the discourse around that particular provision. We've sat in the public hearings where we've heard certain institutions come forward and raise some concerns about the extended mandate. The presentation will attempt to deal with that and provide reasons as to why we are of the view that the extended mandate falls within the confines of the Constitution. Chair, I did a presentation, Advocate Makinda and myself, a few weeks back at the Gauteng legislature, where we said that often local government asserts that they are an over-regulated institution, and to have another institution that will perform that monitoring and oversight function will just add to the level of oversight bodies that they are responsible to. But at the same time, we feel that, a mere look at the situation in our country at the moment. A few weeks back, the Auditor General released a report on local government, where amongst others, she indicated that a total of 219 municipalities had spent 1.47 billion rand on the use of consultants to develop financial statements and financial reports. And even worse than the 1.47 billion spent on that exercise was the finding by the AG that in the vast majority of matters, those reports produced by consultants didn't actually make or fit the criteria or requirements which the AG has in fact put in place. So in actual fact, those reports were not fit for purpose, if I can use that phrase. And that speaks to a number of issues. It raises the question about the level of professionalization or professionalism within the local government sphere. Do we have the right individuals to do the right work? If we are spending all of that money on consultants, what does it say about the chief financial officer and his or her staff under him or her, and their capabilities and capacities to actually perform the functions for which they've been appointed? And it also raises the issue of fruitless and wasteful expenditure. So if there is a vast number of funds being spent on consultants and to produce work that is actually not fit for purpose, what is being done to actually recoup, in certain instances, those those losses that could be sustained within the local government sphere. And as the Public Service Commission, we feel that we have a role to play within that environment. If you look at the current sphere of work that we perform and the impact that we've made in provincial and national government, we feel that this bill will assist the country as a whole, to ensure that high standards of ethics and professionalism and value for money, amongst others, will be ensured when it comes to the local government sphere. Chair, I'm going to stop at this stage, but there is just a quote that I would like to read, if I can find it, because I think it sums up one of the key purposes behind this particular project that we've engaged on it, and it speaks to the development of a capable and developmental state, as is prescribed in the NDP. And this particular document says a developmental state needs to be capable, but a capable state does not materialize by decree, nor can it be legislated or waved into existence by declarations. It has to be built brick by brick, institution by institution, and sustained and rejuvenated over time. It requires leadership, sound policies, skilled managers and workers, clear lines of accountability, appropriate systems, and consistent and fair application of the rules. To achieve the aspiration of a capable and developmental state, the country needs to enhance Parliament's oversight role, stabilize the political administrative interface, professionalize the public service, and upgrade skills and improve coordination. Chair, I submit that the presentation that we will deliver on the bill must be seen in the context of this, and Advocate Makinde will present to you the reasons why we feel that this bill will go some way in addressing the noble intentions as is prescribed in the National Development Plan. Thank you, Chair. At this stage, with your indulgence and approval, I'm going to ask Advocate Makinde to proceed with the presentation. I'm not sure if the committee secretariat will be flighting the presentation, Chair. We just need to be guided on that.
Thank you very much. Ms. Kamish Ahmed, are you going to be in a position to screen the presentation?
Chair, as per our email to the department, we ask that they flight their own presentation. If they can't, then I will. Otherwise, because they know to monitor the next page. Mr. Soul, do you want me to do that?
You can just tell me if it is showing. I'm beaming it from my side.
Not at this point.
It's come up and you click.
Yeah, I did.
We will open it first.
Yeah. Ms. Kamish, I'm getting a message from my side saying we're having, okay, there it seems.
I see it.
Okay. Given.
Good afternoon, Honorable Chairperson and honorable members of the legislature. This is a presentation of the Public Service Commission. The presentation outline. The presentation deals with the objective of the PSA bill, the institutional practice review, the priority areas addressed in the PSA bill 2023, the constitutional parameters in respect of the PSA mandate to local government, progress report on the PSA bill, and the proposed way forward. In terms of the objective, which Commissioner Seal has already mentioned, the PSA bill was introduced in Parliament in the 6th administration, and it continued with the 7th administration to achieve the following objective. The first thing is we want to repeal the Public Service Commission Act of 1997. The main reason why we're repealing this act is to improve the independence of the PSA, like the Commissioner have said, and also to make sure that we implement the full mandate of the PSA in line with the Constitution. Because this PSA Act of 1997 was mainly focused on the public service, looking at the national and provincial department, which is not necessarily correct and aligned to the Constitution. Hence, we are repealing that act. Now, the promulgation of this new PSA bill of 2023 is to focus on that establishment of the PSC Secretariat to enable the Commission to operate as an independent and impartial constitutional body with its own secretariat. This is in line with Chapter 13 of the National Development Plan. And if we look at this, this whole thing, you will see that even the Constitution says there is a single public service commission for the Republic. So in order for us to do this work, it has to be covering the entire Republic. 196.2 talks about the Commission is independent and must be impartial and must exercise its powers and perform its functions without fear, favor, or prejudice in the interest of maintenance of effective and efficient public administration and a high standard of professional ethics in the public service. Now, to do that, the Commission must be regulated by national legislation. So this bill now that we are promulgating is promulgated in line with this section to make sure that the Commission is independent and it is impartial and it's able to do its work as stated in the Section 196 and 195 of the Constitution. Now, the implementation of the application of PSC mandate to municipality and public entities is to promote cohesion in governance while recognizing the nature and function of the different spheres of government. This is in line with the resolution of Parliament, which they took on the 15th of November 2011. And if you look at that resolution, it is aligned to the Constitution. Parliament took that resolution in light of Section 1952 of the Constitution, which talks about the constitutional values and principles. And it says the above principles apply to administration in every sphere of government, organs of state, and public enterprise. So because there is a single public service commission for the Republic, the National Assembly took a resolution that the PSC must implement its full mandate. The PSC must then report on those implementation of those mandates and the application of these values across the three spheres of government. If you look at the Municipal Systems Act, it also recognizes that the values apply even in local government. Now, the achievement of the policy objective and service delivery impact will be better monitored and evaluated by the Commission because now we'll be able to speak and give data and statistics of what is happening across the country, because that's what Parliament wants, so that we are able to do a comparative analysis and give a picture of how things are doing. Now, to improve the efficiency and impact of the PSC in the public service and within public as part of building a capable, ethical, and developmental state. We are in a developmental state. So the principle of professionalism is introduced to say that everybody must be professionalized, and professionalism is across public administration so that we are all capable, we're ethical. It is believed that if the ethics and the principles in Section 195 are obeyed and entrenched in our attitude and the way we do things in public administration, there will be a better service delivery. Therefore, once that is done, the PSC needs to be included in the PFMA as a constitutional body because that is what should have happened normally, but that has not yet happened. So once we are able to get this done, that will happen. Now, it will also...
Sorry, can we please just make sure everyone's muted, except for the presenter? Thank you.
Thank you, Chairperson. It is also to strengthen the enforcement mechanism of the PSC as per the recommendation of the National Development Plan, which says we must strengthen our enforcement. So some people say they want to give the PSC the truth because sometimes they just find people not implementing the recommendations or the direction of the PSC. So it felt that there is a need to strengthen the PSC so that its work can be taken more seriously. Now, it is also meant to align the condition of service of commissioners with the determination of remuneration of public office bearers, which is to be in line with Section 2195 of the Constitution, as clarified in the Public Service Commission Act. Now, like I'm saying, the issue of strengthening the enforcement mechanism of the PSC is very important, and that has been captured. We will take you through it as we are going through the bill, and also to align the condition of service. This is made to make sure that we create a PSC that is able to reposition itself, to re-entrench itself, to re-vibrate, you know, so that it's able to perform.
Can anyone hear me? Because it appears you're frozen.
She's frozen, Chair.
It's frozen, yes.
Oh dear. Could I ask you just to maybe check with the department what their issues are, because they also aren't able to load their presentation. So it seems to be some sort of connection problem. Ms. Kamish Ahmad, should we just maybe adjourn for 5 minutes? You can just talk, just give them a ring and see if we can sort the problem out.
Chair, I'm trying to call them in again.
Okay. Look, it's 13:25. Let's recommence at 13:30. That's in 5 minutes. So we can just see what's going on. Thanks.
Chair, apologies. It seems as if we've had a technical glitch on our side with the connection. Can you hear me?
I can hear you.
Apologies about that. We've had some connectivity issues from this morning. Chair, if I could perhaps ask, I don't know if it will assist us, if Ms. Kamish could perhaps flight the presentation, seeing that we're having some challenges. Perhaps that will assist the connection issue that we're experiencing on this side. Apologies for that again.
Ms. Kamish Ahmad, would that be possible?
I'm on it, Chair.
Great, thanks very much.
Thank you very much, Chair.
Okay, now we can see it again.
Thank you, Chair. Sorry about that. And I would not use a camera in order not to put the strain on the network. Chair, I was already on slide number 5. Yes. So the whole idea of having the new PSA bill is to align the condition of service of commissioners with the determination of remuneration of public office bearers. And this is in line with section 2195. And also to strengthen the enforcement mechanism of the PSC as per the recommendation of the National Development Plan, aligning the condition of service there. And this is just to promote a high catalytic impact role in building an effective, innovative, developmental, ethical, and responsive public service. We can go to slide 6. The PSC then, in order to deal with some of the challenges, undertook what we call an institutional practice review, which led to us developing a business case in order to look at the problems and what we need to achieve. We also did the social economic impact assessment of the bill so that we are able to put our heads together before the bill was then finally put together. So the National Development Plan states that the PSC is not a policy-making institution. It conducts investigation, undertakes monitoring and evaluation, and provides advice and guidance in respect of policy development in the public service. Therefore, the PSC plays an important advisory role in policy making, which means now they then ask the PSC about advice on the structure and governance of the state. So the work of the PSC is relevant and responsive to the National Development Plan. So we did this benchmark exercise and we consider the OPSC independence. We look at the service capacity constraints within the PSC itself. We look at how to improvement of the PSC enforcement mechanism. We look at the PSC power to issue recommendations vis-a-vis the power to issue directions. We look at the use of alternative dispute resolution, which is the new thing now so that disputes don't get prolonged. We look at appointment and removal of the PSC commissioners' processes and how to improve and streamline those processes. We also look at the remuneration of the commissioners. We look at implementation of PSC mandates in local government and public entities. The comparative analysis in those processes look at some of these issues, look at the Southern African Regional Public Service Commission, because we do have a relationship with them in the SADC, and some other public service of Singapore, Public and Discipline Force Service of Mauritius, which we understand they are already doing local government and all of that. So we are also looking at how they will do it. We look at the PSC of Uganda, the PSC of Kenya, Australia, National Personnel Authority of Japan. Now, having looked at those institutional practice review, what is clear under the benchmark study is that the PSC is currently the only constitutional body that is supported by a national government department. And then we look at it and say, you cannot be part of a national government department as the OPSC, we call it the Office of the Public Service Commission. When you want to be neutral, you want to be able to work across the board, across the country. So we should establish our own PSC secretariat, such as the other Chapter 9 institutions have also done. They all have a secretariat with a CEO, not a DG. So once this is done, we will no longer have a Director General, we'll have a Chief Executive Officer. So, and this principle was emphasized in that case, which the Commissioner has already mentioned, that the importance of the principle of independence of constitutional bodies are that these entities should be and manifestly be seen to be outside government. So the independence of the PSC is to create a PSC that is not part of government. Hence, we do not actually have a minister, and we don't report to the executive, we report to Parliament. We report to the Parliament as a constitutional body. So if you look at that, some of the Chapter 9 institutions, South African Human Rights Commission, for example, they have independent secretariat, Commission for Gender Equality, they have an independent secretariat and all of that. So that's exactly what the PSC2 is trying to do. Now, looking at the content of the bill itself, the preamble of the bill sets out the purpose for which the bill is meant to do. It says, this bill is meant to regulate the Public Service Commission in accordance with the provisional section 196 of the Constitution, because this bill cannot change what the Constitution has already said. So what we are just doing is emphasizing, giving procedure and processes and making it clearer. So it's meant to give effect to those provisions, and also to regulate the procedure for the appointment of commissioners of the Public Service Commission, to provide for the establishment of the Secretariat, which we have spoken about now, and to repeal the Public Service Commission Act of 1997 and provide for matters connected therewith. The bill started with a Part A. Part A as definition and application. It deals with definition of basic things that we need to talk about. It provides that, like, the definition of local government as defined in Section 151 of the Constitution, public entities in terms of the PFMA, public service as defined in the Public Service Act of 1994, and then the Secretariat of the Commission in terms of the Public Service Commission Bill and other critical matters that require a definition. This act actually says under application that the PSC applies in relation to administration of the public service and public administration. So if you look under definition, we have already defined what is public service. We also defined public administration, and then the application is across now, not only public service, it includes public administration. Part B of the bill deals with the Public Service Commission itself. It talks about the constitution of the commission. In terms of the constitution or composition, if you must say, there are 14 commissioners as prescribed by the Constitution. These 14 commissioners are made up of 1 commissioner per province and 5 commissioners at national level, which makes 14. So this 14, we cannot change it. It is as prescribed by the Constitution. And then clause 4 deals with the appointment of commissioners. This clause deals with the recommendations of the minimum appointment requirement for commissioners. All we are doing here, the bill has already said you must be a fit and proper person, you must be a South African, and all of that. Then we're trying to say, okay, what is fit and proper person? It's not easy, but we want a commission that is also professionalized. As we are saying, other people must be professionalized. So it is important that they also have degrees, because they will be dealing with a lot of HODs that are required to have NQF level 9. So we actually prescribe an NQF level 8, and then we look at the relevant qualifications as examples that could be used as a benchmark. And we want them to have at least 8 years management experience in proposed area as stated in clause 3, 3.3b of the PSW. Now, clause 5 of the bill deals with disqualification from appointment as commissioner. This clause is aligned to the constitutional provisions. It states the disqualification criteria to be considered in the appointment of a commissioner. The provisions are introduced to ensure that there is a fit and proper person appointed as commissioners. If you look at that, we even talk about things like if you are a parliamentarian and you want to join the PSC, you need to have a 2 years cooling off period so that PSC commissioners are not seen as politicians, and you cannot be an office bearer of any political party if you are a commissioner. So those things are part of the disqualification from appointment criteria. Now, clause 6 deals with limitation on performing other work by commissioners and the renewal of the term of office of commissioners and vacation of office by commissioners. Commissioners are full-time appointments, so they have 5-year term of office. The Constitution recognizes that 5 years can be renewed. So we don't have that clarity as to how this renewal is to be done, but this bill tries to put some criteria to say if the commissioner has worked and all the report has been done, so they should be able to submit a report for Parliament to consider, or the provincial legislature, and you don't really have to re-advertise. The commissioner's term of office should be able to be renewed for another 5 years. The PSC commissioner cannot be a political party office holder, like we said, and cannot perform remunerative work outside the public service commission without the president's approval. This does not mean that the legislature will not know. If it's a person that is appointed through the legislature, you must inform the legislature and then obtain the president's approval. A commissioner may resign by giving 120-day notice to the president, and if granted, it also addresses other conditions that may also lead to vacation of office by commissioners and grounds for removal from the office. You see, like if you want to remove a commissioner, you have to have a commission of inquiry, such as the one similar to what happened in the times when they were dealing with the public protector matter. So all of that is now trying to be built into this process. Clause 7, this chairperson and deputy chairperson. We know that the president designates who is the chairperson and who is the deputy chairperson, but it also deals with how to manage a situation where one or two of them is not in the office. If the chairperson is not in the office for whatever reason, the deputy chairperson will have to be the person that is acting. If both of them are not in the office, then one of the commissioners may be appointed by the president for a period not exceeding 30 days. It's just to be able to distinguish between vacancy and just not being in the office. If that 30 days is continuing for too long, they can renew, and then they can then say, okay, the post is actually vacant, and then decide on how to fill it and designate another chairperson. Clause 8 deals with remuneration and other conditions of appointment of commissioners. This clause provides that the remuneration and other conditions of appointment of commissioners shall be determined by the president from time to time by notice in the Gazette, after taking into account the recommendation of Independent Commission for Remuneration of Public Office Bearers. Currently, the remuneration of commissioners is determined by the president, but it doesn't take into account the recommendation of the Independent Commission for Remuneration of Public Office Bearers. And constitutional bodies, all their remuneration should be done through that commission. So this is something that should have happened already around 2018. So this bill is just meant to align and to make sure that the correct processes are followed, because we don't want to be part of the public service. We are supposed to be a neutral and independent body. Clause 9 talks about inspections by the commission. The commission normally has the power of inspections. It provides authority for the Public Service Commission to conduct inspections of documents and have access to the premises of a government institution within the public service or public administration should such inspection or access be required for the performance of its functions. As we know, no one must inhibit the work of the PSC, so it's important that they are granted access to information that they need when they are conducting an investigation or an inquiry. Investigation by commission. The power of the commission to conduct investigation and to have access to all necessary requirements and information was just reinforced in the Act, which we said we normally have because it also forms part of our current legislation. We're just reinforcing it. Summoning of witnesses. The Commission may conduct an inquiry into any matter that falls within its mandate. It further deals with the process of issuing summons, which in a way it's the same thing as a subpoena for witnesses or for documents. Fines may be issued for non-compliance with summons or subpoena and subsequent consequent management or disciplinary action. Access to reports of the Commission. This regulates access to the report of the Commission, but that access is now aligned to the Promotion of Access to Information Act. As you know, personnel information might be personal information of people, so we have to be careful about how we release them. So that releasing of the report and the personnel information will be done in line with that Promotion of Access to Information Act. Then implementation of decisions of the Commission. The relevant executive authority or relevant person to whom a decision of the Commission has been issued must implement it. That is part of what we have done to say we're giving tooth to the PSC. So whether it is a recommendation or it is a direction, you have to implement it. You cannot just keep quiet and refuse or ignore it, because that is based on certain court decisions that we have now received, which has now said that is the position. And that position we have now been able to build it into the Act. So if a person to whom a direction of the Commission has been issued believes that he or she has a valid reason not to implement the direction, the matter must be taken on review in a court of law. Normally, we also built into the legislation to say you have 60 days to come back to the PSC to say, okay, I agree, this is my plan of action, this is what I'm doing, and so on and so forth, so that the PSC knows what action we are taking because we want improvement in service delivery. The independence and impartiality of the PSC was also affirmed in clause 14, where it says that commissioners and employees of the PSC, in the performance of their constitutional duty, no commissioner or employee may deal with a matter in which they have pecuniary interest or any other interest which may preclude him or her from performing his or her duty in an unbiased manner. We are required to be impartial in terms of Section 196(2) normally. But as part of reinforcing and making sure that those ethical conduct that is required, we also are binding ourselves to that. So we have just included that section in the bill. Now, obstruction of the Commission. Provisions, remedies, and penalties for where any person obstructs or hinders the work of the Commission. This includes fines, the opening of a criminal case at the police station as may be necessary. Now, Part C deals with that independence of the Public Service Commission, where now it is establishing the Secretariat. The Secretariat is the administrative arm of the PSC, which will be supporting the PSC in the implementation of its functions. So that clause 16 deals with the establishment of the Secretariat and provide that the administrative and technical support to the PSC. This will be without any change to the continuous service of employees who are going to be absorbed through a process which is called function shift into the Secretariat. And there are transitional arrangements that are dealing with all of that. Now, the delegation of Commission's power. The Commission normally delegates to a particular commissioner or a committee or a chair or deputy because we have our own internal governance rules. And we have what we call complaint rules, grievance rules, and all of that. So this is just recognizing that we do all of that and we will be making those delegations as those rules are made, which in normal processes they will have said they are regulations, but we call them rules. The finances and accountability of the PSC is dealt with under Part D. The finances of the PSC will still be in terms of the PFMA. It has its own vote. The Auditor General will still audit the accounts of the PSC. And the general provisions are contained in Part E, which is the legal proceedings, which will still be a legal entity. The rules, like we have said, will be made as we are still doing it, because some of these things will have to be flashed out better in the rules and as we go along, so that things are better regulated and clearer. Repeal and amendment of the laws is there. The transitional provisions. Part of the transitional provisions is that the bill will be implemented in stages. The first part will be to establish the secretariat and to build the internal capacity. And following that will be the implementation of the mandate in local government and municipalities, which will be done in phase by phase, and hoping that at least within 3 years after the establishment of the secretariat, they will be in a full capacity to be able to implement fully across the board. And then there is the short title in the bill. Now, looking at the constitutional parameters relating to the PSC mandate on local government, this is just to talk generally, as to say, we recognize Section 151 of the Constitution, which deals with status of the municipalities that must be established for the whole republic. 1513 says that a municipality has the right to govern on its own initiative the local government affairs of its community, subject to national and provincial legislation provided for in the Constitution. So the PSC does not take the place of local government, and it's not going to do the work of local government. It is an oversight body to just continue to conduct its oversight as it is going to be doing, and making sure that everything is working, that even the national and provincial government are also providing support to municipalities as they are required to do under Section 1513. Therefore, the object of local government is to provide services that are stated in Schedule 5 and 4, which are those areas that are specific to them and the concurrent areas of responsibilities. And the duties of local government are developmental and must take into account the need to provide municipal services in an equitable and sustainable manner. This is important for us because we look at now the district model of service delivery that the national government is now looking at, to say service delivery must be at the heart of the people, and it must be done at closest to the people. Because we say if government is not functional, they don't say it's local government. Government is not functional, it's government is not functional. So we have to unblock and unclog this so that we are all effective. And the need for human resources and accountability of local government, in terms of Chapter 7 of the Constitution, the local government sphere of government consists of municipalities. A municipality has the right to govern, like we have said, and then we recognize, I'm now on slide 19. We recognize Section 1557 of the Constitution, which states that the national government, subject to Section 44, and have the legislative and executive authority to see to the effective performance of the municipalities. So generally, we just look at the number of municipalities that are here, the metros and all of that, just to show that there is quite a lot of municipalities. So we'll have to then, as the process unfolds, engage and say, in your area, what do you want us to do? How can we assist you? We have a lot of diagnosis, like my boss have already said now that they are using 1.4 billion to prepare annual report that is not compliant. So the question is, why do we have that? What is wrong with our recruitment processes? Why can't the CFOs and the finance section do their own annual report? So we have to find, we know the diagnosis, we have to find the solution together so that together we can make local government functional. So the whole idea is to promote accountability and avoid basic reactive intervention. I'm now on slide 23. We want to avoid basic reactive intervention with very limited discretionary power. This will ensure that those assigned the duty of service delivery to local communities, municipal functionaries are held accountable if they fail to perform their constitutional and legislative mandates. The Constitution of South Africa provides that South Africa is founded on the supremacy of the Constitution and the rule of law. The Constitution is the supreme law. The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid. An obligation imposed by it must be fulfilled. And you will see that also in Chapter 1 of the Constitution. It talks about the supremacy of the Constitution, how people should be treated, how we must have elections, and all of that, the sovereignty of the state. So if that is so, and we must then build a single public service commission for the Republic, so we must make sure that there is that alignment and there is that ability to have cohesion in government across the three spheres of government. Section 196(1) of the Constitution states that the commission is independent and must be impartial and must exercise its work. So as an impartial body, it is important that we make sure we're impartial. Now, to talk about progress report on the PSC bill to date. The PSC bill has been on a very long journey. You will see that Parliament took the resolution in 2011, and we've been on this journey for a very long time. But in 2023, the bill was published in the National Gazette on the 9th of June. A notice on the bill was published in 2 national newspapers for public comment. Written inputs were received from 16 institutions, and only 3 did not fully support the bill at that time. But now I can say that those 3 have actually now support the bill, because with further engagements, they now understand what the whole thing is all about. The PSC bill was approved by Cabinet in September 2023 for tabling in Parliament. The bill was certified by the Chief State Law Advisor and went through the 1st to the 4th reading. The PSC bill 2023 was tabled in Parliament on 13 October 2023. And the Parliament also, through the Portfolio Committee, published this bill for public comment with a closing date of 16 February 2024. However, the 6th administration could not finalize the bill in Parliament, and this was then taken over by the 7th administration. On the 25th of July 2024, the 7th administration revived the PSC bill. The PSC bill 2023 was then presented in the Portfolio Committee on 4 September 2024, where they also held public hearings between 29 October to 2nd December 2024. The Portfolio Committee adopted the bill on the 5th of March, which Commissioner Searle has already mentioned. This bill was then presented to our Minister, MPSA, on the 17th of March 2025 in preparation for the 2nd reading of the bill in the National Assembly. The National Assembly adopted the PSA bill anonymously on the 18th of March 2025. The PSA bill is now before the NCOP. This is why we are here with you. This bill that is now before the NCOP was presented to the permanent members on the NCOP joint sitting on the 13th of May 2025 to the Select Committee on Cooperative Governance, Public Administration, Traditional Affairs, Human Settlement, Water and Sanitation. After that, we have then presented the bill to the Gauteng Legislature on the 30th of May. We presented to 1 or 2 local governments, municipalities. Even this morning, we presented to 1 local government. And we also presented to COCTA on the 10th of June 2025. We're actually going back to Gauteng again, I think on the 23rd of June 2025. Way forward. The PSCB was consulted with a number of stakeholders, as you have seen. Now, the implementation of the PSC mandate in relation to local government and public entities, like we said, will be suspended for a period of 12 months after the bill is passed, so that we can have that function shift. Because we need to establish that independent secretariat first, so that we have the capacity to start working. Function shifting to the secretariat to be concluded first. The implementation of the full mandate across the public administration should commence fully within those 3 years of passing the bill, and the PSC bill will progressively be built as the PSC will progressively build its capacity, and will consult with you. What do you want us to do? Because we have to be selective as to where do you need help? How can we assist? How can we leverage on each other? Our stakeholders, where do we meet? How do we work together? So that will enable us to roll out this work in a progressive way. So the president have said, we need a state, in the state of the province addresses, we need a state that is capable and competent, underpinned by a professional public service. South Africans want a state that treats all people with dignity, humility, and respect. A state with leaders who are prepared to serve our people with complete dedication. The public servants who are ethical, skilled, and properly qualified. We align ourselves to this. That is why we are talking about ethical, democratic, developmental states. So that is what the president wants us to achieve, and we are focusing on that priority of government. Now, hence the PSC's focus on the government priority of building a capable, ethical, and developmental state. So the transition arrangements and the function shift in the bill will go along as the budget of the implementation comes in. Slowly, the budget will come in, and then we'll continue to improve, and we'll continue to look for other sources of funding. We'll also be able to charge for some of the work. We will also be looking for alignment and working with stakeholders, so that together we can then make this thing work. So the condition of service of current employees will be maintained, like in the secretariat, as we have said, it's just a function shift, will be included in the PFMA, the achievement of better coordination of professionalization of the public service, because everybody must professionalize so that we are all accountable and we have good governance across public administration in order to build a capable, ethical, and development state. This will be the priority. The structure of the funding model will have to be progressive, and we are saying that this should start to be coming into shape as the bill is moving forward. So let me just take you to the next slide where you see our leadership. As in the Constitution, we have 14 commissioners. These are our commissioners. The chairperson is there, Professor Samado Afikeni, and Ms. Zukiso Mkolomba is our deputy chairperson. You have all our commissioners there. We only have one vacancy. That vacancy is in Northwest, and hopefully they will be filling that vacancy. However, Professor Mandla Makaya is taking care of that province as a caretaker commissioner correctly. Thank you very much. That is our DG and the management team. Thank you.
Thank you very much. Is that the end of the presentation?
Yes, yes, Madam Chair.
Okay, lovely. I'm going to allow members to ask any questions before we excuse you, if you don't mind. Members, if you have any questions, please raise your hands now. This is your opportunity. I'm not seeing any hands. Members, going, last chance. Okay, gone. I just want to thank you very, very much, Advocate Searle and everybody in the department. We really appreciate your presentation. I presume we have a copy of the presentation for our record purposes. And as it seems we're not going to get any questions, the committee is going to have to deliberate also on the way forward. So from our side, thank you very, very much. We appreciate your attendance and we can then excuse you. Thank you. Committee, we obviously stay on. We have other things on our agenda.
Thank you very much, Chair, for the opportunity, and we wish you well with your deliberations. Thank you.
Thank you very much. Okay, Procedure Officer, can I then proceed?
Yes, Chairperson.
Thank you. I might need a bit of assistance with this particular portion, as this is still new to me. It's the first time I've chaired negotiating mandate report. So this is point 3 on the agenda. It's the consideration and adoption of the negotiating mandate report on the Public Service Amendment Bill and the Public Service Management Amendment Bill. It's 2 separate mandates, and we're going to do it as 2 separate documents. There were obviously the inputs from the public hearing phase, which was forwarded to members on the 25th of April 2025. And then I have taken the liberty of drafting a committee report to be considered and then adopted. And what I have done, and also with the amazing help of our procedural officer, inserted all the public comments made on the bill into the negotiating mandate report. So what will happen is we can then go through the report to make sure all the comments are there, and then decide whether or not we're going to express our support for the bill. If we can't amend the bill, we either support it as is, or we express a support for the bill subject to certain proposed amendments. In other words, if the proposed amendments are rejected, the committee will not support the bill. Third, express our support for the bill not subject to certain amendments. However, amendments are proposed in addition to the committee's support. In other words, if the proposed amendments are rejected, we still support the bill. And then the final two options are we do not support the bill, and we give reasons, or we abstain from voting on the bill during the negotiating mandate stage. So I think if we can start with let's get this right. I always manage to confuse myself with these two. On the Public Administration Management Amendment Bill. If you can possibly screen the relevant bill there, Procedural Officer.
The Public Service Amendment Bill.
Is that 10B 2023?
Okay, make it that one. I will flight the draft report. I
Having such very similar names, I always manage to confuse myself slightly.
Yeah, mine PSA. Okay, can you see it?
Yeah, we've got that. Okay, that is, you'll see 10B of 2023. All right, the Standing Committee on Premier and Constitutional Matters, having considered the subject of the bill, referred to it in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP, we'll come back to this, to not support or support, and proposes the following amendments. Now, I do find it frustrating not being able to scroll. I understand that these are also all the issues that were raised in the public participation. Am I right about that?
Correct, Chairperson.
Great. I'm assuming everybody has read this document. I think to go through it, I mean, we can go through it now if people want me to, but I'm hoping everybody has read it. In which case we need to decide if we're going to support or not support this bill. And I'm waiting on proposals from the committee. Ms. Kamish Ahmad?
Maybe just to give the members some guidance. So in the public participation process, all these comments were it was presented to the committee. And what you've done, you've included all the inputs from the public input into this report. If the members are in agreement that they want to include all the input from the public participation with public made suggestions of two different clauses, and that is what is presented in front of the committee. And that is, so they're basically going to send their negotiating mandate by saying, these are the proposed amendments, and for now, the committee either does not support it until these proposed amendments are made, and if these proposed amendments are made in the final mandate stage, the committee will then support the bill. So we're at the stage where we took all the public participation inputs, and we've now drafted a negotiating mandate, and now the committee must just decide whether they support or not support the bill in its form, or they want to propose these amendments. Thank you.
Hang on, let me just get this right in my own mind. So we could say that we would support we either support the bill or we don't support the bill, or we would only support the bill if these amendments are incorporated into it. Is that
correct, Chairperson?
Okay, all right. Member van Wyk?
Chair, just perhaps for everyone, if we could just scroll through what we've got before us, because I think this runs to 3 pages, if I'm correct.
Yes, it is.
Yeah, that we can just take that through slowly, that we just everybody's on board with what we've got here.
Okay, so we have the option then of saying, I'm not going to use the right language. I'm afraid the presiding officer, procedural officer will have to correct my language. Essentially, the option would be we would potentially support the bill if these amendments were made. But I see there's also a general exclusions clause on page 3 saying that we have the right to reconsider our opinion. Have I got that right?
Okay, in the negotiating mandate, yes, but when it comes to this portion of the negotiating mandate, you either support the bill or not support the bill. If we look at
Oh,
the
I
different
see.
options, yeah. So if you see
So we could say we do not support the bill and propose the following
Correct.
amendments,
Correct,
which would then
Chairperson.
be the 3 pages,
Yes,
but we still retain that, what I would call the sort of variations clause at the end, which means that we can reconsider our opinion.
correct, Chairperson.
Okay.
Yeah, it's exactly what Chairperson said in the beginning. You express to
Yes.
support the bill, but it's not subject to propose amendments. And then the second option is you express your support to the bill, but the support is subject to certain proposed amendments. Or you express your support for the bill, the support is not subject to certain proposed amendments. So if the members and if the committee does not support the bill, reasons for such non-support, you can say that you do not support the bill. Your reasons for the non-support is as such because of these. Or we can say, based on the proposed amendments, we will support it in the final mandate stage because we will get another date for final mandate stage, and we will. So the national department will be meeting on negotiating mandate. They'll receive all the input from the different provinces. They will then incorporate. We'll see if they incorporate it or if they don't. The department incorporates it or not. If it comes back and we see that the bill is still in the same format and none of the proposals made from the public input, then you can either reject the bill because none of those proposed amendments were incorporated into the bill.
So it's basically a case of having your cake and eating it, really. Member Walters?
Chair, I would like to propose that we oppose this, subject to these amendments being adopted.
Okay, I understand. Member Lecker?
Thank you, Chair. As the ANC, we are in support of the bill with the amendments proposed. Thank you.
Okay, so we have the ANC saying that they're in support, subject to the amendments. Am I right? And then Member Van Wyk?
Yeah, I think I was going to second Member Walters' proposal. Yeah.
Okay. If I can just find out, then we can do, in terms of section of Standing Rule 90, there can be the ANC expressing its minority view. Am I right there?
Chairperson.
Okay, all right. So we do not support the bill and propose the following amendments. But obviously, in terms of Standing Rule 90, the ANC expresses minority view to support the bill.
Yes, Chairperson.
I just want to find out, is there a viewpoint from the PA at this point? Is there a separate viewpoint from the PA? Not at this point. Okay, all right. So is it then clear on Bill 10, B of 23, what our position is?
Chairperson?
Yes.
It's Johan. May I speak, please?
Yes, of course. Please go ahead.
Oh, Chair, thank you. I raised my hand, but maybe I can't see it because there's something on the screen, the document. Chair, I was just wondering, sorry, maybe I'm just slow. But I don't understand the position of the committee. I'm not saying there's anything wrong with it. I'm just saying I don't understand it. Because is the committee now saying that they do not support the bill, but they're still making proposals?
That's what I was trying to understand in terms of the language.
Because sorry, Chair, if I can continue, because I understood if you have a position to say that we support the bill subject to the following changes, it's kind of the same of saying we don't support the bill, but if you make these changes, then we'll support the bill. It just sounds more positive. I could be wrong, Chair.
The way I understand it, okay, Member Walters?
Yeah, Chair, perhaps it is a bit confusing, but the way I understood it is this is an initial position, and based then on a final mandate will be determined at a later stage. And the reason for opposing the bill is because I think it's important to stress the importance of those amendments that we want. So that's why I propose that we oppose the bill, and then when the final mandate comes back to us, then that point one can reconsider.
Yeah, I understand it in terms of the conclusion paragraph on page 3, where it says the Western Cape Provincial Parliament reserves the right to revise this position pending 1, publication of a comprehensive socio-economic impact assessment, 2, proper consultation on revised provisions, and number 3, clarification of resource implications. So I understand that as our sort of variations clause, that we can change our mind if amendments happen and it is then renegotiated. I agree with that. Stevens?
We fully agree with that, Chair. The PA fully agree with Member Walters.
Thank you. Member Lecker?
Thank you, Chair. Perhaps, Chair, we need a proper guidance in this regard, because if we are to say the Western Cape Parliament reserves its right, whereas there's still a minority view from the ANC that explicitly said we are in support of this bill, there seems to be a confusion there. So maybe we must seek for a proper guidance from Johan and as well as Wasima in this regard. Thank you.
Thank you. Ms. Kaush Ahmed, have you got a view on how we can just word it clearly?
Wasima, do you mind if I go?
Please, Mr. Pamela.
No problem, Johan.
I'll speak. Wasima, just flight that report again, please. While Wasima is bringing the report up, Chairperson, I want to say that the minority view is a standalone view. I don't think the minority view clashes with anything, because the rules provide for a minority view. So if any party wants its minority view recorded, that's fine. It doesn't influence the report that the committee has adopted. It just reflects the minority view. I also understand what was explained by Mr. Walters and the committee. Now I understand the position. I just think we must get the wording in the first paragraph right then, because there's nothing wrong with that position, because this is why this is called the negotiating mandate stage. because this is the stage now when provinces negotiate. So you can say that you don't support it, but you are making certain proposals, and then after that you might support it, because that's what negotiation is all about. Or you can say it in a different way. You can say that we do support this bill, subject to the following proposed amendments, or whatever your position is. So I don't think there's any conflict of interest or anything wrong. Gosima, I don't see the report yet.
That clarifies it.
Okay. I just think this sentence, the second sentence, we just get right. It says the standing committee, blah, 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 having considered the subject of the bill, referred to it in accordance with Rule 217, confers on the Western Cape's delegation in the NCP the authority. It should say there to not to support the bill. And then we must agree the wording, and further proposes the following amendments.
Okay.
Something like that, because I think that was the decision.
And then just to formulate the minority view aspect there in terms of Standing Rule 90.
Yes.
And
We'll
then we
just say-
propose those amendments, and at the end we then have the clause that essentially says we have the right to reconsider, but the issue reconsidering does not affect the minority view that's going to be expressed here.
Yeah, and we don't have to say that, Chairperson, but if the
Okay,
committee
no,
wants
we
to,
don't have to say it, but I'm just saying,
Yeah.
is that
I'm just thinking, Chair, sorry. It may be good, because if we're going to say in the beginning here that we do not support the bill, and we further propose the following amendments, I'm thinking aloud here, it may be good to bring that last clause into this whole paragraph, to make it clear from the beginning that the committee could reconsider if you guys as the NCOP take into account our proposals. Or you can leave it at the end. I just thought it might be a good idea.
look, it's always safe to have a get out card,
Yeah,
because I mean things might change in the future, so it's
Yes,
always
yeah.
useful to have it, even if one doesn't use it. Member Walters?
Chair, I would suggest one adds into the report, the mandate will be reconsidered depending on progress on the amendments.
Look, I like that, I must say. Great. All right, everyone, so then we can get that drafted. Can we just have a final sign of it before it's obviously submitted? And then can we move on to the next one, which is the Public Service Amendment Bill 13B of 2023.
Now with you, Chair.
Okay, this is the same principle, but maybe we can just scroll slowly through this one. Okay, I'm also assuming that people have read this one. Do we have any proposals on the way forward with this one? Member Van Wyk?
Yes, Chair. I think just looking at the conclusion there, I think that in a sense, to me, sort of sums up the position that it seems to me what we're saying is we are not supporting the bill at this stage, but will reconsider the position provided the amendments, then deal with the matters that we have raised.
Okay, so you're proposing the same as we did on the previous one. Member Lecker, are you also going to express the minority view on this?
Correct, sir.
Thank you very much. And Member Walters?
Yeah, Chair, to me, it's very similar to the previous matter. It's at the end of the day a negotiation mandate. And it's suppose with the wording in there, depending on the extent to which our inputs are accommodated, we will reconsider our position.
Yeah, I think that's clear. Member Lecker, is that a heritage hand or do you want to add anything?
It's a legacy hand, Chair.
Thanks very much. Okay, so we then deal with this one exactly the same. We don't support, we propose amendments, we reserve the right to reconsider, and the ANC has expressed minority view in terms of Rule 90. Member Stevens, I know you don't have your hand up, but I just want to know if there's any input from the PA.
We feel exactly the same as the rest of my colleagues, Chair.
Lovely, thank you very much. Okay, so if I can just, Member Walters?
But Chair, it's not to engage a debate, it's just purely for clarity. Of course, the ANC is perfectly entitled to their position. I just wanted to be clear in the beginning, Member Lecker referred to support the bill, subject to the adoption of the amendments. Is that wording reflected in the minority view? Or did I understand correctly?
We can just maybe get guidance from the procedural officers.
Chairperson, thanks. I would prefer if Member Lecker will confirm her position just to clarify it for all of us.
Member Lecker?
Thank you, Chair. The ANC is in support with the second bill, subject to the recommendations that have been made in the first instance. Thank you, Chair.
Thanks. Okay, so we're clear on those two negotiating mandates. Then we need to move on to point 4, if we finish with point 3, the discussion on the way forward for the Public Service Commission Bill. That is 30B of 2023. We haven't received a formal program for this bill yet, as I understand, but we can proceed with our hearings to make sure that we actually get through everything. I know moving forward, we do have constituency period for most of July. But I think let's at this particular point just discuss in principle, how many hearings should we have on this bill? Should we do the different locations or should we do what we did last time, which was have hybrid hearings? And then obviously we need to make a decision to advertise in the mainstream papers and also obviously follow our own internal process. So can we have thoughts on the public participation process? How many hearings and where should we have those hearings? Should they be hybrid or live? If I can see some hands. Member Lecker?
Thank you, Chair. I will start with the number of public hearings that we may have. I wish to propose for 6 public hearings meaning targeting all the different regions that we have within our province. Two, I'm a bit skeptical in having a virtual kind of arrangement, because in the main, these are the public participation processes that are supposed to be feasible and reachable to everyone that we wish to reach. So for me, having this kind of hybrid is a situation taking into account the economic conditions of our people. And I would therefore wish to propose once again that we have an in-person kind of arrangement when we're doing our public participation instead of a virtual. Alternatively, we can have a hybrid situation. Thank you, Chair.
Thank you. I just want to remind the committee that last time we had 3. One was hybrid in the chamber, and we had people who came down, particularly from the West Coast area. And then we had 2 virtual hearings. So, and those were for the 2 bills that precede this bill. So I think we also need to be commensurate with what we did last time. Member Walters?
Chair, I happen to think that if a virtual hearing is done correctly, it could be very inclusive. And Chair, let me say why. If we simply send people a link, then I think the eventuality that Member Lekker describes, I think, is true. However, if there are in facilities across the Western Cape, libraries, places like that, if there's a opportunity given there for people who want to make submissions, to make use of facilities there in an organized manner, you can actually reach more people. It's something we've discussed, and I think it's maybe something that should, as an approach, as a supplementary approach, should be further discussed. The formula that we used in my committee was 3 public hearings. That was constrained by the program that we had at the time, and potentially it was also, to be fair, not a particularly controversial bill, but 3 physical hearings, 1 in the Metro, 1 in the West Coast area of the Western Cape, and 1 then in the Southern Cape area. And then we had, on top of that, also a virtual hearing, just to maximize inclusivity. So I would suggest that's a model that might work for this as well.
Thanks. Member Stevens?
Yes, thank you, Chair. I will also suggest, I think the public hearings did work better than the virtual ones, because I remember the Friday, there was a virtual hearing and nobody came up to the hearing. And I know we waited another 10 minutes and nothing happened. So I think we must rather stick to the public hearings. Chair, that's my 2 cents.
Thanks very much. Member van Wyk?
Yes, Chair. Look, I think if we have public hearings, the difficulty that we have, even if we follow what Member Walters has indicated, one on the West Coast and the other sort of on to deal with the South, you have a situation where anybody who wishes to give evidence or to come and express a view, that person would have to travel to that venue. I would perhaps think that possibly one does have a hearing, and one can then do it by way of a hybrid hearing in arrangement with the municipalities, for instance, on the West Coast, one meeting, and that we put out an element of publicity for that, and that possibly through the municipalities, they can make available a facility if somebody wants to come and give evidence wherever they are, and we can deal with it in that manner, and split it into the Metro towards the west and then towards the south, and in that way give people in various municipalities that opportunity to express their opinions.
Okay, so there are quite a few suggestions here. May I suggest that what we do is, because we don't yet have a formal program, can we investigate the possibilities of how we could facilitate hybrid hearings in terms of our regulation so that we do sort of encompass both aspects? And then we can revisit this at the next meeting. I just want to find out. Yes, I was going to now. I just want to quickly find out, Ms. Kamish Ahmad, if we can maybe, in terms of our timelines, do we have time to, I want to come to Member Lack and Member Walters now, do we have time to look at that and then come back to this at our next meeting?
Chairperson, because we don't have a program, we can take this avenue. If members just want that exercise to be done, they just need to let me know what areas they have in mind, because we'll obviously have to ask ICT, supply chain, if those facilities actually if we can actually do such a setup. So if we want to go to the West Coast and we say we want to do a public hearing in Saldanha Bay, we'll actually have to find a hall, and we have to see if that hall has the facilities to have a hybrid setting. So it's I know that we have a hybrid setting. We normally try and have that in the chamber, and then everyone can actually just join online wherever they are.
Okay, thanks. Member Lecker?
No, thank you, Chair. I'm sure I'm going to sound as a nuisance, but from listening to the areas that were identified the last time there was public hearings, I did not hear anything from the Boland area. So I want to check if I buy the proposal by Member Walters, which at least sounds like a middle ground, is there any provision to cater for Boland as well? Because I did not hear any mentioning of Boland as a region. Thank you.
Member Walters?
No, that's not for him to answer, Chair. It was just a proposal.
No, his hand was up. That's why I'm just asking him. But he seems to have taken it down.
All right.
Mr. Famila?
Yeah,
Chairperson, thank you. Oh, sorry.
Hold on. We've got Member Walters back again.
Sorry, my apologies. I pressed the wrong button. Yeah, I should have pressed the mic, and I lowered my hand by accident. My apologies for causing confusion.
With your car, don't make that mistake with the brake and the accelerator.
Chair, the regions that I'm proposing, that was by way of example. I think the key point is that we identify geographic areas and treat a hybrid as a supplementary. And we had a very similar discussion in my committee, as some of you will recall. At the end of the day, the main constraint, it's not about willingness to see people, the main constraint is the program. So, Chair, I think we have a couple of proposals there. I would suggest that Chair, that you perhaps look at all the proposals, and then once we have all the requisite information, bring it back to the committee. That's what I would suggest.
I think it's probably a very good proposal. Mr. Famila?
Chairperson, thank you. I just wanted to latch onto your proposal. I suppose Mr. Walters as well then. And Wasima did say, yes, Chairperson, we do have time because we don't have an NCOP program yet. Chairperson, will it make sense? Because there is now 4 weeks of constituency for the chairperson, for the committee to maybe so long put out an advertisement and just advertise the bill, and then ask for members of the public that they must can either give written proposals or indicate whether they would like to be participate in a public hearing, so that we can just gauge what the appetite is out there, Chairperson. The reason I'm making the suggestion also, Chairperson, and then Wasima can also write to all the municipalities, because I think I did hear Mr. Saul say that they've consulted extensively with the municipalities, and all the municipalities, less 3, and those 3 are now on board, are they are on board with this bill, which tells me that the bill is not really controversial. So it's, I would say, mostly for municipalities, but there would be people out there that might be interested. My only thing I wanted to mention, Chairperson, is that obviously it's for committee to determine where it wants to hold public hearings. But sometimes, Chairperson, it's dangerous to, well, not dangerous, maybe that's not the right word, but sometimes it's better to determine, I think that's what you said, where to hold public hearings once you just get a little bit more information from, who's interested out there. Because we've had obviously situations in the past where we've organized public hearings in various places and then like 1 or 2 people show up because either the bill is not controversial or they're not really interested or whatever the story is, Chairperson. And because there's time, I'm just suggesting that maybe the committee puts out an advertisement like that to gauge the public interest, and then with that information, the committee can always make a decision after the constituency period, because we'll probably run the ad for 2 or 3 weeks. And when constituency is finished, and we'll also do social media campaigns, then maybe the committee will have access to more information. That's just my suggestion. Thank you, Chairperson.
I think that's a very good suggestion. I mean, if one looks at precedent, when we did the first 2 bills in this trio, we got input from the Western Cape government, from 2 civic organizations. People were at the hearing, but nobody actually spoke to the bill. So I'm also wary of us wasting public money going to areas where, other than being interested, one's not really going to get much resonance. So I think let's do that. Would the committee agree that we follow that course of action, as we do have time in our hands?
No problem.
Okay. All right. Thank you. Thank you, Member Johnson, as well. Okay, right. So we'll proceed with that course of action, as we are also going into constituency for several weeks. Then item 5, resolutions and actions. Any resolutions, recommendations? Speak now, forever hold your peace, so to speak. Yes, Member Walters.
Chair, I would assume that what we just discussed is a resolution of the committee for minuting purposes.
Yes, that can then be formulated as such. Thank you, Ms. Kamash-Ahmed, for agreeing there. Anything else anybody wants to raise? Not. Okay. Thank you all for your participation. Thank you very much. And we shall no doubt speak again soon. The meeting is adjourned. Thank you. And I'm inviting you all to have a cup of tea in your own kitchens. Thank you very much.
Thank you, Chair. Thank you, everybody.
Bye.
Bye.